Ladies and gentlemen, good morning, good afternoon, or good evening. Wherever you are in the world, we appreciate you being with us right now. This is Lovey Life, a DOM podcast. DOM is a digital and bilingual media company specialized in law at the supranational level. So, for all news, comments, analysis related to law in Africa and the rest of the world, go to our website dom-online.com and follow us on our social media platforms, the links of which are listed below. This, however, is neither a technical nor a political podcast. To be honest, sometimes it's barely a legal one. The only prerequisite needed is to have an open mind and 30 minutes or so to spare. We sometimes will have guests from everywhere around the world, and we will always be keen to hear your thoughts. We have a fantastic episode for you today, so please stay with us and weigh in while we argue the case. Lovey Life. First things first, Happy New Year, people. Wherever you were, we hope you had a fantastic holiday season. May all that is beautiful, meaningful, and bring you joy be yours in 2023. Now we are starting a new year and a new season of our podcast, and I am so very excited about what we have in store for you. We decided to shake things up a bit. The first season was me rambling, let's be honest, and to be sure, this will still happen. But in this season, we also will have interviews that I think are insightful and funny, and we will have a more thorough breakdown of cases. For our first episode, we are diving into a fascinating case. I know I say that a lot, and I am biased because I love my job and I love law, but I mean it. I specialize in international law because I thought it was an exciting area, mainly due to the fact that as opposed to other areas of law, the links between international law, politics, and diplomacy make for a fantastic background. Yes, the notions and instruments we talk about may seem very dry if you're not passionate about law, but even so, it always comes to life in the most intriguing way. And who does not like a little bit of intrigue? The case we are going to focus on today is certainly one of the best examples for that. The legal notion we are going to talk about is consular access to a national detained abroad by his or her country of origin, the regime of which is encapsulated in the Vienna Convention on Consular Relations. That, on the face of it, would seem fairly boring, I know, but bear with me, and I promise you may just like it, because our case today is so incredibly interesting. It would actually be a very good script for a movie, I think. So, without further ado, we will talk about the case opposing India and Pakistan on the issue of Mr. Kulbushar Jadhav that was heard before the International Court of Justice in 2019. First of all, and as usual, we need to frame the issue because this is necessary to understand the rest of the case. As you know, India and Pakistan have a very storied history, and they are not always on the best of terms, diplomatically speaking. One of the points, if not the most important point of contention, is the matter of Kashmir, a region that is in the north of both India and Pakistan and the far west of China. So, if we recall our history lessons, we remember that there have been 4 wars between India and Pakistan. The first one at the end of the 40s, between 1947 and 1948. The outcome of these conflicts was the partition of the Kashmir region between Pakistan, India, and China. The problem, of course, is that no one is actually satisfied with the repartition of the land. No. To be fair, it's not entirely true. China has no stated issue with its allotted portion of the land. India, however, continues to ask for control over the historical Kashmir, meaning all the land that was previously part of the British Empire, while Pakistan claims dominion over Jammu and Kashmir, which is, as of now, under Indian control. So, the whole thing is a complete mess, and the backdrop of the story of our lead character. For good measure, I should also point out that this area is the most nuclearized region in the world, as the three neighboring countries all have a proven working nuclear weapon. So, suffice to say that we all have a vested interest in ensuring that cooler heads always prevail. Now, who the hell is Mr. Kulbushar Jadhav, which is, for the purpose of our story, the lead character? Well, this is where things get interesting. There is no universally accepted answer. What we can say for certain is that he is an Indian citizen born on April 16, 1970. His father is a retired Mumbai police officer and his mom is a homemaker. He is married and has 2 kids. That's it. That is the only information we can take for granted. Everything else is a bit foggy. For example, what does he do for a living? Well, the answer depends on who you're asking. According to the Indian government, the man was working for the state of India as a naval officer from 1987 to 2001. Fair enough. But, according to the Pakistani authorities, the answer is quite different. If he did indeed start his governmental stint in 1987, he never stopped and he is still active. Another point of contention: what exactly did or does he do in his day-to-day mission? It is a very easy answer for the Indian side. He does nothing at all when it comes to government activities, at least. According to official records, Mr. Jadhav no longer works for the state, as he took a premature retirement in 2001 and joined the private sector. This is a quite different story from the Pakistani side of the border. According to them, after officially leaving the Navy at the beginning of the 2000s, Mr. Jadhav was enlisted in the Research and Analysis Wing, which is the Indian External Intelligence, and was tasked to gather intelligence and carry out subversive and disruptive missions for his government. Quite a different version, as you can hear. Which one is the truth? I genuinely have no idea. What do you think? I'm curious. Last but not least of these puzzling questions is, what are the circumstances of Mr. Jadhav's arrest? Well, again, completely unclear. Pakistan affirms that Mr. Jadhav entered the country under a fake identity, that of a Mr. Hussein Mubarak Patel, with a fake passport and the goal to destabilize Pakistan by strengthening a separatist movement in Balochistan and Karachi, a mission which officially began in 2013. He was arrested on March 3rd, 2016, during a counterintelligence operation in Balochistan. This is quite a different version of that of the Indian Foreign Ministry, which alleged in a formal press release that Mr. Jadhav had relocated from India to Iran after leaving the government, started a business, and was either lured and or kidnapped in 2016, and, this is a direct quote, that his subsequent presence in Pakistan has never been explained credibly. End of quote. Some in the Indian press state that the fake passport was actually created by Pakistan to suit their narrative. Clearly, both versions cannot be reconciled. Someone is lying. As to which one, well, your guess is as good as mine, but you cannot tell me that this is not a better plot than any of the last James Bond movies since Casino Royale. Okay, let's look at the legal aspect of things, because after all, this is a vaguely topical podcast with law in the title. Mr. Jadhav stood trial before a martial court in Pakistan for 3.5 months, where he was accused of espionage for India, waging war against Pakistan, sponsoring terrorism, and destabilizing the state. He was convicted and sentenced to death on April 10, 2017. This was confirmed by an appellate court. What was a particularly damning piece of evidence was a video recorded during his interrogation, where Mr. Jadhav confessed being guilty of the charges. He states, and this is a direct quote, "I am still a serving officer in the Indian Navy and will be due for retirement in 2022. By 2002, I commenced intelligence operations. In 2003, I established a small business in Chabahar in Iran. As I was able to achieve undetected existence and visits to Karachi in 2003 and 2004, and having done some basic assignment with India for RAW, which is, again, the Indian External Intelligence," we continue the quote, "I was picked up by RAW in 2013. End of quote. That seems pretty bad, right? However, India challenged in the strongest terms this whole process, starting with the circumstances of the arrest, detention, interrogation of Mr. Jadhav, all the way to the choice of jurisdiction, having a civilian stand in front of a martial court. The Indian government also took exceptions to the circumstances in which the video was obtained, stating that it was a doctored piece of evidence, clearly designed to defame India, and as such holds no legal weight and should not have been admissible in court. The main grievance, from a legal point of view, was that the Indian government was denied access to Mr. Jadhav, one of his citizens, during his arrest, detention, and trial, despite having requested to be involved in the proceedings repeatedly. Having dubbed this trial, quote, farcical, India looked to stop the execution of the sentence. One such avenue was filing an application instituting proceedings in front of the International Court of Justice, which is, incidentally, why this case came under our attention. Now, here I need to make a quick stop. For those of you who are familiar with international law and international institutions, this will be a fairly obvious point, and I apologize. But in the off chance that some of you don't understand the inner workings of the international legal realm, this needs to be stated. Okay. International law is the only branch of law where the main subjects are states and other legal persons, such as international organizations. Natural persons, meaning you or I, are only very rarely the direct subject of international jurisdiction, unless we are acting as a representative of our states, or, obviously, if our criminal liability is under question. Most of the times, in international law, disputes arise between two states over the interpretation or alleged violations of their international obligations. In this case, India alleges that since the arrest of Mr. Jadhav on March 3, 2016, the High Commission of India has requested to the Pakistani Ministry of Foreign Affairs consular access to its citizen. That request has been reissued more than 20 times during the whole proceedings, leading to the sentencing of Mr. Jadhav without ever having been granted. This, according to India, constitute a breach of Pakistan's international obligations under the Vienna Convention on Consular Relations. In addition of filing an application instituting proceedings, India also requested the indication of provisional measures to stay the effect of the sentence in Pakistan. What does that mean? It is pretty much self-explanatory. Provisional measures are measures that a party may request the court to take as a matter of emergency. You see, cases can take anywhere between 2 to 5 years, or sometimes even longer, to be heard by a given international court. That is a long time, and there are instances where time is of the essence. So, when a party wishes to ensure the protection of a situation or a right, or wants to make sure that the subsequent judgment is not devoid of purpose, said party may request the court to issue these provisional measures, which are at the discretion of the court. If the judges are satisfied that there is a matter of urgency and an imminent risk of irreparable harm, said measures will be issued. Now, it is fundamental to note that the fact that the court agrees or refuses to issue provisional measures is in no way an indication on how it will rule on the merit. Again, it is just a matter of protecting a legal situation where a peril exists. That's it. In the case of Mr. Jadhav, the court granted India's request to issue provisional measures because, well, let's not forget that Mr. Jadhav was sentenced to death. And, had he been executed, the claim before the court would not only be devoid of purpose, but, more importantly, Mr. Jadhav's right would have been irreparably compromised as he would have been dead. So, the International Court of Justice ordered Pakistan to stay the execution of Mr. Jadhav until such time as the matter was heard before the court. We keep talking about rights and obligation of the person and of the states. Let's get a bit more specific. What India is alleging, by essentially barring the state to communicate with its national while it was being detained in a foreign country, and preventing India to assist Mr. Jadhav during his legal proceedings, Pakistan had broken not only Mr. Jadhav's human rights, but also Pakistan's international obligation, to which the state had subscribed when signing the Vienna Convention on Consular Relations. For ease, we will refer to it as the Vienna Convention, even though we should not, because there are in fact many Vienna Conventions. In the Vienna Convention, to which both India and Pakistan have agreed, we are, remember, talking about the one on consular relations, there is an Article 36. Try and remember that one. This Article 36 deals with communication and contact with nationals of a country when they are in a different state. Under that article, consular officers must be allowed to communicate and have access freely with citizens of their respective states. The consular officials are also entitled to be kept apprised by the competent authorities of any development when a citizen of their country is arrested, detained, and or tried by foreign courts. The consular officials are also entitled to visit their citizens while the latter are in detention and arrange for legal representation, unless the national that is in prison specifically opposes that option. Finally, and quite logically, every person arrested, detained, and or tried in a different country has to be made aware of his or her right to contact the consulate of his or her state of origin. According to India, none of these provisions were enforced by Pakistan, and this would constitute a clear breach of international law. So, what is the response of Pakistan and the answer of the court? Well, I'm going to try and walk you through it because there are two big categories that we will need to keep in mind. One that deals with procedural answers and another one that deals with substantive ones. Okay. So, for the procedural issues first. In virtually every case, the defense, here the state of Pakistan, will raise preliminary objections regarding jurisdiction of a case and admissibility of an application. Basically, those are the two main reasons why a court or a judge would throw away a case, meaning take it off the roll without looking into the merits. Jurisdiction deals with the question of the forum, meaning where the case is filed. For example, a soldier that is appearing in front of a civil court for acts done during his or her duty. And in that example, the civil judge will say that he lacks jurisdiction to hear the case and look no further. In our case, that was not an issue. The second big procedural issue is that of admissibility, meaning reasons why the court, though having jurisdiction over a case, should not hear it. And those reasons can be multiple. Here, Pakistan raised 2 points. First, an issue of abuse of process and abuse of rights, by contending that India had prematurely started proceedings before the International Court of Justice without looking for alternative legal or diplomatic remedies. That argument did not fly, and the court ruled that India was within its right to file the motion when it did, with regard of both the context and the sentence of Mr. Jadhav. The second issue was a very interesting one to have at that stage of the argument. Pakistan invoked the clean hand doctrines as a ground for inadmissibility of the application. Now, the clean hands doctrine basically states that a party cannot seek remedy or equitable relief before a court when that party either relied on its own shortcoming or had committed illegal acts pertaining to the case in question. Basically, one must come with clean hands, which, according to Pakistan, India did not by, and this is a quote, refusing to provide assistance in the investigation of Mr. Jadhav, end of quote. In that regard, the court applied its settled case law, under which an objection made on the basis of the clean hands doctrine is not enough for the court to rule an application inadmissible. Have I lost you so far? It's very simple. Simply put, the court said that not only it had jurisdiction to hear the case, but that the case was also admissible. Once it has done that, the court can now turn its attention to the merit of the case. We've already heard the main argument of India, right? Which is the violation of the Vienna Convention regarding consular access and relations. Now, let's look at the answer of Pakistan. It's an interesting mix of arguments, I must say. The first argument Pakistan made was that the Article 36 of the Vienna Convention we have talked about, which is the one that governs the access of consular officers to nationals of their countries when they are arrested, detained, and or tried in another country, does not apply to cases of prima facie espionage. Prima facie means on the face of it. You know, we lawyers will find a way to use a Latin locution whenever we can. But what Pakistan is contending is that cases of espionage were not considered to fall within the scope of the Vienna Convention, and that matters of espionage of national security were capable of constituting a justifiable limitation to the freedom of communication between a state and its citizen, when said citizen is detained abroad. India obviously refuted this argument and stated that the text of the Article 36 of the Convention does not list any exception to the right for consular officials to get into contact with one of their citizens, and that if the reasoning espoused by Pakistan were to be carried to its logical conclusion, any state could justify the denial of the rights provided by the Vienna Convention by alleging acts of espionage. The court agreed with India's position, emphasizing that nothing in the text of the article provided for an exception related to espionage charges. The second argument raised by Pakistan is essentially the same, but deals with customary international law instead of the Vienna Convention on consular relations. The court also rejected that plea. We will not spend too much time on it, but for the legal rationale of these arguments, please go to our website for the complete breakdown of the case. The third and last argument of Pakistan is fairly interesting. You see, both Pakistan and India signed in 2008 an agreement on consular access that we will refer to as the 2008 Agreement. And in this agreement, there is a provision that states that in case of arrest, detention, or imprisonment of either an Indian or Pakistani national in the other country, made on political or security ground, each side may examine the case on its merit. So, Pakistan contends that this is a relevant provision that should govern the Jadhav situation and not the Vienna Convention. However, for India, the existence of this bilateral agreement is inoperant and does not prevent the state of relying on Article 36 of the Vienna Convention on consular access. In this instance, the court concluded that the 2008 bilateral agreement was, and this is a quote, to confirm, supplement, extend, or amplify the Vienna Convention. So, they agreed with India. The Vienna Convention is the superseding legal instrument. This is the one that should be applied, the governing provision, that is Article 36. So, if you have followed up until this point, first of all, thank you. Second of all, congratulations. The legal argument was whether the Article 36 of the Convention was applicable to the case, and the court concluded that it was. Now, the judges had to decide if Pakistan had indeed violated its obligation under these provisions, and more specifically, if Pakistan acted in breach of its obligation under Article 36 by not informing, without delay, of the detention of Mr. Jadhav, by not informing Mr. Jadhav of his rights under Article 36, and by denying consular officers of India access to Mr. Jadhav, contrary to their rights to visit him, to converse and correspond with him, and to arrange for his legal representation. The court concluded in the affirmative. As a remedy, the International Court of Justice ordered Pakistan to inform Mr. Kulbushar Jadhav without further delay of his rights and to provide Indian consular officers access to him in accordance with Article 36 of the Vienna Convention on Consular Relations, as well as provide, by the means of its own choosing, effective review and reconsideration of the conviction and sentence of Mr. Kulbushar Jadhav. That was in 2019. On November 18, 2021, Pakistan enacted a law that would allow Mr. Jadhav the right to file a review for appeal against his conviction by a military court. This is still pending. In the meantime, he remains on death row. So, the story is not over. So this is a developing and ongoing story. If you would like to know what happens next, go to our website dome-online.com and follow us on our social media platforms. We will keep you posted. Thank you so much for being with us today. I want to hear what you have to say. Do you have any comments, question? Does it make sense or does it not? Leave a comment below the link of the episode on our social media platforms using the hashtag LoveyLife. The transcript of the program will be available on Dome's website in both French and English. If you have enjoyed this episode, please consider sharing, liking it, and subscribing to the show. We have had some great episodes previously, and we would be very grateful if you would consider listening to them. We will be back with our next episode next Wednesday. In the meantime, please stay safe and take care of yourself.